Do you think it's was appropriate for Boeing to pay its current CEO $18 million in compensation for 4 months of work? 4 months of work, while it at the same time eliminated the health care benefits for 3,200 machinists in St. Louis. Is that the kind of approach that you would use as a member of the NLRB?
I have not been involved in the negotiations in St. Louis. I've been specifically kept out of those negotiations because in anticipation of this process.
You are the chief labor counsel for Boeing, and you have no knowledge or not been involved in the strike in St. Louis?
That's correct. We have other lawyers that are handling
Well, all right, but you are.
Senator Bernie Sanders put a surgical light on what this hearing was really about. Whose side is the National Labor Relations Board going to be on? The people who build our country, or the corporations that pay CEOs millions while stripping workers of basic protections?
Let me start off with Mr. Mayor. And, Mr. Mayor, in your remarks, you talked about fairness and compromise and trying to bring people together. You are now the chief labor counsel at Boeing. As you're aware, there's been a strike going on for 2 months now. And I want to get a sense from you as to about that strike, because I think it will tell us a little bit about what kind of member of the NLRB you will be. So let me start off by asking you a very simple question, and that is, do you think it's was appropriate for Boeing to pay its current CEO $18 million in compensation for 4 months of work? 4 months of work, while it at the same time eliminated the health care benefits for 3,200 machinists in St. Louis. Is that the kind of approach that you would use as a member of the NLRB?
Good morning, Senator Sanders, and thank you. Let me start out by saying that I'm not here as a representative of Boeing. I'm here to discuss my nomination. Secondly, Senator, I have not been involved in the negotiations in St. Louis. I've been specifically kept out of those negotiations because in anticipation of this process.
You are the chief labor counsel for Boeing, and you have no knowledge or not been involved in the strike in St. Louis?
That's correct. We have other lawyers that are handling.
Well, all right, but you are a high-ranking member of the Boeing Corporation, so I'm giving you information which is accurate, whether you've been involved or not. You want to be a member of the NLRB, you tell us you want to treat workers fair. Do you think it's fair that workers lose their health benefits during the strike while the CEO gets $18 million for 4 months' work? Sound fair to you?
Senator, I'm not going to comment on the compensation of other executives. I will say that there was negotiations in St. Louis. There was this is all public information. There were negotiations in St. Louis. There was an agreement reached with the union. The union hailed that agreement as a landmark agreement.
But that agreement was
recommended.
But that agreement was rejected by the workers.
The union recommended that it be ratified.
But it was rejected by the rank and file. Correct?
And that's their right.
That's right. That is their right. Excuse me.
Yes, sir.
If Boeing could sign a fair contract with 32,000 machinists in the state of Washington, members of the IAM, last year, why can't, in your judgment, it sign a similar contract for 3,200, 10% of the workers, machinists in St. Louis who manufacture fighter jets for the military?
Senator, respectfully, I'm not going to get into, I'm unable to really comment on the negotiation status for our negotiation in St. Louis.
Let me ask Mr. Murphy, thank you. Let me ask Mr. Murphy and Mr. Palmieri a question, and that is, SpaceX, as you know, is owned by Elon Musk, the wealthiest man in the world, and Amazon, owned by Jeff Bezos. I don't know where Jeff is now, maybe second or third. He's struggling, but he's up there. They have both filed lawsuits arguing that the National Labor Relations Board is unconstitutional. In other words, you're aware of that, Mr. Murphy. Simple question. Do you believe that the NLRB is unconstitutional?
No, I do not, Senator. The Supreme Court in 1937 in Jones and Laughlin Steel found that the National Labor Relations Act was constitutional. Unless there is a definitive Supreme Court decision to the contrary, I believe that it remains constitutional. There may be constitutional infirmities that could be redressed, but that would not negate the constitutionality of the agency.
Thank you. Mr. Palmieri?
While I don't have a specific view, I would agree that it has been found constitutional in the past.
All right, let me ask you if President Trump directs you to rule in favor of Amazon or SpaceX and in opposition to the rights of their employees, would you do so?
It's a hypothetical that I hope never comes to pass, sir. I would have to contemplate all options.
The problem that we are living in is a moment where a lot of things that we didn't think would pass are passing. So I guess what I'm asking you, will you have the independence to say, sorry, Mr. President, I've got a job to do? Or will you say, yes, sir, I'll do it?
I might say, depending upon the circumstances, sir, that I question that directive and under the law that I'm obliged to apply. And if the Supreme Court holds, as it apparently would on a procedural basis, that the president has the opportunity to remove me, then the president would have that option.
Okay, thank you.
When Sanders asked whether it was appropriate for Boeing CEO to collect $18 million for 4 months of work while 3,200 machinists in St. Louis lost health care, he wasn't making a rhetorical point. He was testing whether a nominee who spent his career as Boeing's chief labor counsel understands the everyday stakes for working families, and whether he can be trusted to sit on the NLRB and apply the law impartially. The NLRB exists to enforce workers' rights to organize and bargain collectively. It's supposed to be an independent referee when employers and unions clash. That independence isn't abstract. It's how the system protects people who don't have leverage at the bargaining table. Single parents who can't afford lost wages, veteran machinists who maintain our military hardware, and entire communities that depend on stable wages and health benefits. Appointing a high-ranking corporate lawyer from Boeing to a board whose job is to judge labor disputes creates, at minimum, a severe appearance problem. At worst, it risks turning an enforcement body into a partisan instrument that tilts in favor of powerful employers. Sanders' line of questioning hits two different but related problems. The first is moral and practical. How do you justify enormous executive pay while workers lose health care or face wage cuts? Even if the CEO's contract is legal, the optics matter, and the policy consequences matter more. When corporations prioritize short-term payouts to executives over investments in their workforce, the result is weaker bargaining positions for employees, a race to the bottom on benefits, and growing inequality. The second problem is institutional. Can a former Boeing counsel fairly adjudicate disputes that may involve Boeing or set precedents affecting the entire aerospace and manufacturing sectors? Recusal promises help, but recusals can't solve the structural problem of having decision-makers whose careers were spent defending employer positions against workers. Nominees will often answer by saying they were kept out of specific negotiations or that litigation prevents comment. Those are convenient shields, but they don't answer the voter's central question. Will you enforce the law in a way that protects workers' rights, or will you bend to corporate power? The NLRB's role includes policing unfair labor practices, like employer interference with union organizing, illegal bargaining tactics, or retaliatory firings. If board members are predisposed to favor management, those protections weaken in practice, even if the statute remains the same on paper. There's another legal backdrop here that viewers should know. Major corporations have sometimes challenged the NLRB's authority or its procedures in court. That's part of why the composition of the board matters so much. A board that leans corporate can slow enforcement, issue narrower rulings on what counts as unfair labor practice, or create legal standards that favor employers. That chips away at the ability of ordinary workers to organize for better pay, safer workplaces, and health care. The choice of who sits on the NLRB is therefore not a technical appointment. It's a decision about the balance of power in American workplaces. This hearing also humanizes the stakes. Imagine the machinist in St. Louis who helped build fighter jets, skilled work, often with family health care tied to employment. A sudden loss of benefits isn't a talking point. It's a medical decision delayed, or a child put at risk. It's a household budget recalibration that can push families into debt. When senators press nominees, they're not debating theory. They're judging whether the next NLRB member will reinforce or dismantle the protections those families rely on. So what should viewers watch for next, and what can they do about it? First, pay attention to two things in any NLRB confirmation: clear, specific commitments on recusals, not vague promises, and a record that shows meaningful engagement with workers' rights, not only high-level legal work for employers. Second, ask your senators to demand full transparency. How involved was the nominee in past anti-union strategies? What internal advice did they give? And will they publicly pledge to recuse themselves from any Boeing-related matters with a clear timeline and enforcement mechanism? Third, follow and support the workers directly. Strikes and collective bargaining are how working people build leverage. That matters whether or not a nominee sits on a board. If you want to act right now, here are practical steps you can take. Call or email your senators and tell them you expect nominees to commit to impartial enforcement of labor law and to provide detailed recusal agreements for any matters tied to former employers. Share the story of the St. Louis machinists on social media or with local press so the human cost is visible. If you're able, support union strike funds or community organizations helping affected families. Finally, show up at town halls or hearings and ask nominees the hard, specific questions Sanders asked, not hypothetical abstractions, but direct, real-world scenarios that reveal how they'll rule when the next labor dispute lands on their desk. This isn't a partisan slogan, it's a choice about what kind of economy and what kind of justice we want. Do we want regulators who stand up for workers and enforce the law, or do we want regulators who defer to the wealthy and powerful? Sanders' questioning was a reminder that nominations matter. They decide whether institutions protect ordinary Americans or whether they become another route through which concentrated wealth dictates outcomes. If you care about fairness, healthcare, and the right to organize, this is a fight worth following and one where your voice can matter.